A warm welcome to everyone. And I'd like to start out with a small reflection, if I may. Although this meeting is virtual, we all do our academic work on specific Indigenous, First Nations, and Métis territories. Some of these territories are governed by treaties, but some are still unceded. I would ask all of us here to reflect on the conditions under which we occupy these spaces today and always. I am speaking today from Toronto, which is the traditional territory of many Indigenous nations. It has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. Today, it is home to many First Nations, Inuit, and Métis communities. I acknowledge the current treaty holders, the Mississauga of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. And I'd just like to say a couple of words about the Harry Crowe Foundation. The Harry Crowe Foundation, as many of you I hope will know, was established by the CAUT in 2002 as a nonprofit organization. Its mandate is to conduct, promote, and support education and research on issues that are germane to post-secondary education. The foundation is named after Harry Crowe, whose firing from United College, Winnipeg, now nearly 65 years ago, prompted the very first CAUT academic freedom inquiry. In this case, the dual purpose of the inquiry, as noted by the authors, was to provide assistance to Professor Crowe, but also, and I'm quoting here, to strengthen the concept of academic freedom throughout Canada. It is to be hoped, wrote the authors, that whatever the outcome of this unhappy incident, and this had to do with a letter being leaked, a critical letter about an employer, the concepts of academic freedom and tenure and of the teacher's essential role in the community will be more fully understood within and without the profession. And that's very much what our conference is about, we hope. Today and tomorrow, we will be considering the contemporary landscape for academic freedom. Our topic is academic freedom and its legal foundations. Some may find this a rather unusual pairing. Unlike many other countries where academic freedom is governed by statutes, regulation, or legislation, in Canada, academic freedom rights really are contractual. They come through our collective agreements. Part of the board's purpose in pursuing this topic was to come to a better, or maybe a better way to put it is more fulsome, understanding of how legal rights and legal limits, of how the law can facilitate the pursuit of academic freedom and its limitations. The current, it seems to me, the current post-secondary environment offers pertinent examples. For example, the recent Cloutier Commission report calling for the government of Quebec to establish an Academic Freedom Act, and a University of Ottawa report that looking at academic freedom, which muses on the role of the Charter in relation to academic freedom. And while human rights tribunals have had little to say about academic freedom overall, harassment, discrimination, human rights issues have become central to post-secondary conflicts. And academic staff have been disciplined, sometimes, not infrequently actually, severely disciplined for exercising their extramural rights. And finally, the unique nature of the academic workplace continues, especially around academic freedom, continues to come under pressure from employers who are eager to demand brand and corporate loyalty. So there's some of the many questions that I hope will be raised in the next 2 days. And I hope we have a very fruitful conversation. I'm looking to talking with or hearing from many of you and talking to some of you. And I'm going to turn it over to David Robinson, the Executive Director of CAUT and the Secretary to the Harry Crowe Foundation Board just now. And just before I do, David, I realized I forgot to say one thing. The Harry Crowe Foundation, as I pointed out, is a nonprofit foundation. But one of the things as a nonprofit foundation we do is raise funds to support support occasions like this one. And so you will see in your program, at the very back of the program, you'll see a blurb about Harry Crowe, but you'll also see a donor sheet. And so I'd like to ask you just to think about making a donation, and you'll hear this message again. Thank you.
Great. Thanks so much, Penny, and thanks for making the commercial appeal. I just want to take just a few moments to just welcome everyone and thank you for joining us and braving yet another Zoom event. I know we had hoped to be in person, but the pandemic had different ideas. But I still think we have a great event coming up. As far as I know, this is the first major conference looking at the legal foundations of academic freedom in Canada. And our hope is that much of the discussion and papers that come from this will become the major reference point for the topic for years to come, and will be used by lawyers, by arbitrators, and by courts as a reference point. I did want to say a special thanks to Michael Link, who you'll hear from in the first panel coming up, for doing a lot of the heavy lifting and organizing the conference and flagging this as an important issue for us to focus on. I want to thank Penny and the directors of the Harry Crowe Foundation for their work in helping to put together the agenda and thinking about topics to be covered and speakers to reach out to. And of course, I want to thank the speakers in advance. I think it's a stellar lineup. I very much look forward to the discussion and debate over the next 2 days. And with those very brief remarks, I'm going to turn it back over to you, Penny, so we can get started right away with the first panel.
Thank you, David. And we are indeed. Our first panel looks at the current state of the field, examining the strengths and weaknesses of legal protections for academic freedom. We have 5 panelists lined up to speak, and as David said, it's a stellar group. And you will find fulsome biographies for each of our panelists in your program. And with apologies to the panelists, I'm going to introduce them with much more cursory introductions. And I hope I haven't butchered them too badly. Mary Elizabeth, we have 5 panelists, as I said. The first 2 panelists come from the law firm of Goldblatt Partners here in Toronto. And Mary Elizabeth Dill is our first speaker. And Mary Elizabeth has a broad labor and human rights law practice, emphasizing university labor relations. Our second speaker, joining Mary Elizabeth, is Adriel Weaver. And Adriel Weaver is a public law litigator specializing in criminal, immigration, and human rights law. She also represents faculty associations and other professional associations in the health sectors. And they're going to speak for about 15 minutes, and then I'll introduce our third speaker. Thank you.
Thanks so much, Penny. So we have a PowerPoint presentation, and I think that someone at CAUT may be putting it up on the screen. That is excellent. Thank you. So I'll start us off and just also say that Adriel and I are really, really thrilled to be here, and we're really looking forward to all the contributions other panelists and participants have to make over the next couple of days. So if we turn to the next slide, as Penny has already explained, while the importance of academic freedom, it might be one of those, there we go, it's coming. While the importance of academic freedom has been recognized by Canadian arbitrators and courts alike, it's not statutorily or constitutionally protected in Canada. And the strongest source of protection for academic freedom is really contractual through faculty association collective agreements. But that said, it is important to recognize, we think, that Canadian adjudicators have recognized academic freedom as an important legal principle that exists independently of collective agreements. And so if we turn to the next slide, you'll see here that we've provided you with a couple of examples of cases where adjudicators have recognized the importance of academic freedom independent of any contractual foundation. And the first example is the Human Rights Tribunal's decision, 2012 decision in McKenzie and Isla. And I won't go into detail of the facts of this case. I expect it will be discussed on other panels, but just at a high level, this is a case emerging from Brock University it's a dispute between a Catholic chaplain who claimed he had been discriminated against by a faculty member who had actively criticized on feminist and other grounds an international exchange program associated with the on-campus Catholic diocese. And in dismissing the complaint, the tribunal emphasized that restraint should be used when the tribunal is asked to intervene in the affairs of a university in any circumstance where what is at issue is the expression and communication made in the context of an exploration of ideas, no matter how controversial or provocative those ideas may be. And what I think is notable about this case is that, even though the tribunal is its role is to determine whether or not there's been a breach of the Human Rights Code, and it's not to enforce an individual's contractual right to academic freedom, the tribunal nevertheless considers the legal principle of academic freedom separate and apart from its contractual foundation to be relevant to its decision-making. And it actually specifically links academic freedom to core overarching charter values and protections like freedom of expression. And the other case that we have cited for you there on the slide is a decision of the Information and Privacy Commissioner of Ontario. This is actually one of the leading cases on the extent to which universities can require disclosure of faculty member records under FIPPA, which is the Freedom of Information and Protection of Privacy Act. I won't go again into the details of the facts of this case, but here the IPC explicitly recognizes academic freedom as a historic principle that exists independently of, this is a quote, and predates the collective agreement, and that it is more generally an important principle in a democracy. So while it wasn't the IPC's role to determine or enforce academic freedom under the collective agreement, again, the IPC, much like the tribunal did, considered academic freedom, the principle of it, to be important to its decision-making, separate and apart from its contractual foundation. And what I think these and similar cases make clear is that even where adjudicators are not tasked with enforcing and don't actually have the jurisdiction to enforce contractual academic freedom rights, they have nevertheless found the principle of academic freedom to be relevant, and it's arguably affected the outcome of these cases. And this is obviously a positive development, and one faculty associations, academic freedom advocates will want to keep pushing for in any cases that touch broadly on academic freedom issues, whether or not those cases arise in the strict context of a collective agreement dispute. I'll turn it over to Adriel.
Thanks, Mary Elizabeth. Apologies in advance. I'm getting an unstable internet message intermittently, so I may turn off my video at some point just to preserve what connection I'm able to maintain. If we could go to the next slide, please, the protection of academic freedom. So as Mary Elizabeth has outlined, we do have these very broad and in some cases quite forceful recognitions of academic freedom as a principle that both predates and transcends specific contractual arrangements. But it does remain the case that in Canada, in the absence of statutory protection for academic freedom, collective agreements and memoranda of understanding or memoranda of agreement remain the strongest source of protection for academic freedom. And one of the practical implications of this that we encounter every day is that the precise scope of and the limits to academic freedom vary from institution to institution, depending on the relevant policy, the collective agreement, the memorandum of agreement. We could go to the next slide, please. Now, there are some advantages to relying on contract language as the primary protection for academic freedom. The first thing to note is that the vast majority of faculty association collective agreements and similar documents in Canada do contain an express protection for academic freedom. So the good news is there's not an absence. There is a foundation on which to build. And it is within the power of faculty associations to both expand and to particularize the protections for academic freedom that are enshrined in contract language. So for example, one of the things that we have seen fairly hotly contested in some cases, certainly at issue in most over the past 2 years, relates to the academic freedom implications of course delivery, particularly course delivery in the context of the pandemic. So does academic freedom protect the right of faculty members to decide how to deliver a course, subject of course to any public health considerations and regulations in place? And that's an area where faculty associations can lend some specificity to what are, generally speaking, quite broad and sort of hortatory, non-particularized protections for academic freedom. And often the parties can be much more nimble in their approach to issues as they arise. If there are folks here who are engaged in bargaining at the moment, you may disagree with me, but I think in general, the process of negotiating contractual language is, again, generally less procedurally complex than the process of trying to amend statutory language. So there is an opportunity not only to lend that specificity to collective agreements, to the protection of academic freedom, but to do so on an ongoing basis, right? Collective agreements are living documents that are regularly renegotiated and renewed. And so this provides an opportunity for the parties to better express their commitment to academic freedom in more specific ways. And then when there are disputes, the parties can, of course, select an arbitrator who has particular expertise or grounding in the university sector, and who may therefore have a particular appreciation or awareness of the features that make an academic workplace different from many other workplaces. And again, this is an area where we can see some expeditiousness relative to other processes. So certainly not in every case, but in many cases, it is possible to proceed to arbitration much more quickly than it would be to proceed to a civil claim. And then finally, of course, when disputes arise, there is a very strong, in some cases, extremely strong, depending on your arbitrator, push to mediate, to reach a consensual outcome between the parties. And that, in the context of an ongoing labor relations arrangement, can foster a more collegial workplace, can allow for the resolution of disputes in ways that don't leave a fractured state, that allow for some reconciliation of different views. Now, there are obviously some downsides to that as well, as Mary Elizabeth will outline. We don't have nearly as robust a body of jurisprudence as we might because of the tendency to achieve mediated resolutions, but this can be an advantage as well. If we go on to the next slide, I'll turn it back over to Mary Elizabeth.
So sort of on the flip side of some of those advantages that Adriel has just discussed, of course, there's also some challenges that come with enforcing or relying on contract language to enforce academic freedom protections. Like any collective agreement provision, a faculty association's ability to negotiate or bargain for improvements to those academic freedom clauses, protections will be subject to some of the same forces and difficulties that can shape any round of collective bargaining. And we've sort of listed a few of those on the screen. Of course, the reality is that the bargaining team and membership may have more urgent or pressing priorities. Once things, these are long bargaining sessions often, and by the end of it, the parties have usually whittled down their many proposals to a number of key pressing priorities, and academic freedom may or may not make the cut depending on a whole variety of factors. And if we turn to the next slide, similarly, enforcement of academic freedom provisions at arbitration is going to be subject to some of the same principles and challenges an association might encounter in enforcing any other contract provision. So, first, of course, there are the obvious jurisdictional limitations, the employer's collective agreement or memorandum of agreement obligations are only engaged in respect of the rights of bargaining unit members. And so this may seem like a rather obvious point, but it can come up in academic freedom cases, especially as universities begin to rely more and more on more precarious or non-bargaining unit positions to fulfill their teaching needs. And the most recent example that I can think of where this kind of issue has arisen is actually in the Dr. Azarova case at the University of Toronto that I know we're all well aware of. Of course, this is the case where the University of Toronto was on the eve of hiring Dr. Azarova as the new director of its international human rights law program and the Faculty of Law. But then just days after, a major university donor, sitting tax court judge Justice Spiro, expressed concerns over her scholarship on Israel-Palestine, the dean suddenly and unilaterally terminated the hiring process and Dr. Azarova's candidacy. And so this, gave rise to obvious academic freedom and collegial governance concerns. But the point I want to make here is that had Dr. Azarova been hired, she would not have been a member of the Faculty Association. She was a candidate for a non-faculty administrative managerial position, even though the position closely resembled a faculty position in many respects. And so as a practical matter, when the University of Toronto Faculty Association grieved the serious breaches of academic freedom and collegial governance at the core of the scandal, rather than only making the sort of more straightforward argument that Dr. Azarova's academic freedom was breached, the association also had to ground its arguments in the indirect chilling effect the administration's conduct had on the academic freedom of UTFA members more broadly. Had the Faculty Association only grounded its claim in the breach of Dr. Azarova's academic freedom, an arbitrator would have been pretty quick to be dismissive of this as outside of their jurisdiction under the parties' memorandum of agreement, where they only have jurisdiction to enforce the rights of UTFA members, not others. And so these kinds of jurisdictional limitations, they don't mean that academic freedom disputes that originate with non-bargaining unit positions or members can't be grieved, but that there needs to be some way to ground the alleged rights violation in the bargaining unit itself. And this will often be through arguments and evidence establishing a broader chilling effect of the employer's conduct on the bargaining unit itself. We've also listed on the slide, there are some other of the key interpretive principles that can affect the outcome of these academic freedom cases when they're grieved and proceed to arbitration. And these can be opportunities, but also these kinds of principles can present challenges. And just in the interest of time, I have anecdotal examples of some challenges these kinds of principles have given rise to in some recent academic freedom disputes at universities. But in the interest of time, I'm happy to discuss that if there are questions. But if we move on for the time being to the next slide, we see sort of the flip side of Adriel's point that you can choose your arbitrator and you can get arbitrators with particular experience and expertise in the university setting. It's also the case that in some cases you may end up with an arbitrator who has less grounding or experience in the unique features of the academic workplace, and so may render a decision that doesn't take appropriate account, at least in the Faculty Association's view, of some of those unique features. And of course, as Adriel has already said, many of these disputes get confidentially mediated and settled. And so it means we can't speak to some of those interesting kinds of cases that are subject to mediation or confidential settlements, and that the arbitral jurisprudence can sometimes be more limited when it comes to some of the more complex or nuanced academic freedom cases. And I'm going to turn it back over to Adriel now.
Thanks, Mary Elizabeth. If we could continue on to the next slide. I see there's a question in chat. Is there a definition of academic freedom? In my institution, there seems to be a disagreement on what academic freedom is. And I would say that is, across all institutions, a very common feature of disputes between the employer and faculty members. There is this fundamental lack of certainty about what academic freedom is, in part because it is and remains a creature of contract. And so to some extent, it depends on the precise wording of the contract at issue. There are stronger and weaker contractual provisions governing academic freedom. Some features of stronger academic freedom protections are, number one, an agreement that academic freedom is essential to the functions and purposes of a university. So in other words, an institutional commitment that isn't just about the rights, or I think some universities might say the privileges of faculty members, but rather that relates to the fundamental character and indeed the viability of the university and of its mission. Another feature of stronger contractual language is an agreement that the university will not only refrain from infringing upon or abridging academic freedom, but that it will take active steps to protect, defend, uphold, and or to promote it. So not simply a negative right, not to be interfered with in the exercise of one's academic freedom, but a positive obligation on the university and a positive right for faculty members that the university will foster and support academic freedom. And then further to our earlier discussion about specificity and particularity, express recognition of some of the ways in which academic freedom informs the conduct of all actors in the university. So that academic freedom in teaching, for example, includes the freedom to determine course content, to determine teaching methods, to identify the materials to be used. We see this in the Queen's collective agreement. We also have collective agreements that specifically protect the freedom to, quote, conduct frank discussion of potentially controversial matters related to faculty members' subjects.
Just and a minute, please.
Of course.
I'm saying just one more minute. Sorry, my chat just doesn't seem to be working.
Are we okay to proceed?
Yes, indeed.
Okay, thank you. As we'll see, one of the practical ways in which we see academic freedom sought to be invoked, and one of the practical ways in which we also see it sought to be limited, is precisely here in relation to teaching. So specificity around the intersections, the interplay between academic freedom and teaching really strengthens contractual language. We turn over then to the next slide. There is also some contractual language in various collective agreements, memoranda of agreement, that arguably weaken the protection for academic freedom or that impose limits. So one would be the duty to use academic freedom in a manner consistent with the scholarly obligation to base research and teaching on an honest search for knowledge, bracketing even the question of what an honest search for knowledge might be or who gets to make that determination. One of the other questions that arises in relation to this language is what that means for faculty members who are speaking outside of the scope of their particular scholarly expertise and enterprise. Mary Elizabeth is going to talk a little bit about this going forward, but arguably that language would offer less protection for those members than broader language that we see elsewhere. Similarly, we see limits like the duty to use academic freedom in a quote unquote responsible way, the duty to respect the academic freedom of others, the obligation to continue to meet duties and responsibilities in a way undiminished by the guarantee of academic freedom. And then, of course, the requirement that members not purport to speak on behalf of the university in the exercise of their academic freedom. And this can be satisfied in a relatively straightforward way when engaged in publication or public speaking. We've certainly all seen, and I think many of us have written those disclaimers at the beginning of an article. This doesn't necessarily reflect the views of one's institution. It again becomes trickier when we're talking about teaching. It is difficult for people not to draw the conclusion, students not to draw the conclusion that you are, as a faculty member, to some extent, purporting to speak on behalf of the university when delivering a course that the university has determined is required for a particular course of study and has set some expectations around and provided a general description of. So there are going to be areas where satisfying that limitation or the boundaries of that limitation are more and less clear. We could turn then to the next slide. And back to Mary Elizabeth.
Thanks, Adriel. I understand that we're running low on time, so I just want to, I think what we'll do, Adriel and I have a number of other slides. We've been maybe overly ambitious in what we wanted to cover, where we go through some of the lessons from the case law at a very, very high level, some of the key themes that we see in the case law and how some of the contract language, collective agreement language that Adriel has just taken us through have been interpreted by arbitrators. But just given the time, I don't know that we need to get into all of this right now, but we can, with the PowerPoint presentation, I think I speak on behalf of both Adriel and I, we're happy to share it generally, and it has the next few slides, some of those key principles emerging from the case law. And so Adriel, I don't know if there's anything else you want to say to wrap up. I know we've been ambitious in what we wanted to cover.
I don't know that as litigators we've ever been accused of not saying more than was strictly necessary. So I think we can wrap it up there and leave you with our written submissions, as it were, on the rest of the points.
Thank you very much. We'll turn to our third speaker, and that is Professor Michael Link. And Michael is an associate professor in the Faculty of Law at Western University. He teaches in labor, human rights, disability, constitutional, and administrative law. And I'll turn it to you, Michael. And I'll be letting you know on the chat when you have 5 minutes left.
Thank you very much for that, Penny. I believe, and echoing David, that this is the very first conference in Canada on the theme of academic freedom and the law. And I hope that this conference goes a long way to clarifying and enhancing the legal protections for academic freedom in Canada. My presentation is meant as an overview of the current state of the law on academic freedom. I'm going to be echoing probably some of the things that Mary Elizabeth and Adriel have said. And I trust it will act as an entree for the presentations for the rest of today and tomorrow. And if I can express my thesis or my presentation succinctly, it's that I think the law is not working hard enough to be able to establish a broad liberal protection for academic freedom in Canada. If you can forward the slide, please. What I first want to do is just simply point out a comparison between how academic freedom is protected in the law here in Canada and how it's protected in other countries. As you can see from the slide, I emphasize that in America, where unionization rate is around probably 20%, of universities and post-secondary institutions, and the Constitution of the United States, and particularly the First Amendment on free expression, is probably plays a much bigger role in the protection of academic freedom than it would in Canada. In other countries, for example, in the European Union, the Charter of Fundamental Rights has a section which protects both the right to education and a general right on academic freedom. And there are a number of individual countries around the world, as I've listed, who actually provide for protection of academic freedom or for the right to education, which sometimes encompasses academic freedom in their national constitutions. And in all these cases, litigation on the protection of academic freedom is done in the courts. Next slide, please. And very briefly, if I can just point out, this is a statement from international law. There are a number of statements that I could put in here. The right to freedom, the right to education is protected in the International Bill of Rights, in the International Covenant on Economic, Social, and Cultural Rights. But this is one of the clearest statements that we have, issued 25 years ago by UNESCO. And this protects what I'm going to point out to be all four branches that we recognize in Canada as being component parts of academic freedom: freedom of teaching and discussion, freedom of research, freedom of intramural speech, and freedom of extramural expression as well. And the reason I point this out is not simply to say, well, this is a soft law, aspirational statement we find in international law. I can point out to you that international law in the last 5 years is beginning to grow active roots in Canadian law. There are several decisions by the Supreme Court of Canada which have said that when interpreting the Charter, or when interpreting indeed statutes which bring upon human rights issues, we should be looking at international law and making sure, to the degree possible, that human rights law and Charter of Rights is consistently interpreted with international protections in international law. Next slide, please. So, echoing what was said in the last presentation, in Canada, academic freedom is not protected in the Charter of Rights and Freedoms. It's not protected in human rights legislation, and it is very rarely ever found in legislation. I have found it, for example, there is a reference to academic freedom in the University of Regina Act, but in most statutes that I've looked at, which bear upon specific universities or higher education in Canada, there's no mention of academic freedom at all. As was said in the prior presentation, this is entirely a negotiated right found in collective agreements, and it's almost entirely litigated, therefore, in front of labor arbitrators as a labor law right. Occasionally, it winds up reaching the courts where there's been a judicial review sought of a labor arbitrator, or very occasionally a tribunal decision on academic freedom. Next slide, please. So here are the four branches that I've mentioned that we saw in the UNESCO definition recommendation from a couple of minutes ago. We have drawn this, in many ways, we've borrowed a lot of the initial thinking that has come out of the Association of American University Professors statements, the classic ones both in 1915 and in 1940 with respect to academic freedom. And this has evolved into thinking on both sides of the 49th parallel into these four rights constituting the four principal branches of academic freedom. And you'll find this, as Mary Elizabeth and Adriel said, in some form in virtually every negotiated academic freedom clause in every collective agreement across the country. Next slide. So just before I take you through how arbitrators in the courts have dealt with academic freedom in Canada, I wanted to point out this case, and this is simply a representative case of what it's like not to have unionization and not to have collective agreements with academic freedom provisions in them. This case from a little more than 50 years ago is an example of a situation where there is no academic freedom mentioned in any of the contracts of employment. There is no union and there is no collective agreement. And what had happened here is that the Voluntary Faculty Association hadn't been certified as a union, had submitted a statement and had gone through a back and forth with the Board of Governors at Simon Fraser University, wanting to have the university make a statement with respect to the protection of academic freedom. And eventually there was a common language that was adopted, and the Board of Governors accepted it, but it accepted on the express basis that it did not abridge any of their powers with respect to hiring and firing. And if any of you are familiar with the general history of academic freedom and its developments in Canada, you'll know that Simon Fraser University became a hotbed of actions over the protection of academic freedom in the late 1960s, particularly with a departmental strike that occurred in the social sciences. And here, an assistant professor had protested procedures in the department. She joined a departmental strike, and she was dismissed. And she litigated her issue in the courts. And in front of the British Columbia Supreme Court, she argued that the academics' freedom statement that had been adopted by the Board of Governors formed part of her her employment contract. And the Supreme Court disagreed and said that the Board of Governors didn't intend that any legal consequences should come from that. It was simply an aspirational statement with regards to this. And this is probably true with any other statement where there is no unionized faculty or any collective agreement that's recognized as a collective agreement between the faculty and the university, is that unless it's actually expressly stated in an individual professor's contract of employment, or it's in a university policy that's expressly meant to have legal consequences, then academic freedom isn't protected. And that's why we all today would be looking almost solely at what is in collective agreements in order to be able to establish the groundings for academic freedom. If you can go on to the next slide. Sorry, the next slide. There have been statements made by the courts. I've listed here 3 of the broadest statements that I could find over the last 35 years or so. And these are heartwarming for those who believe in a robust definition of academic freedom. But I should point out in virtually all of these cases, none of them are classic academic freedom cases of a university professor or professors wanting to have academic freedom rights entrenched in law. The McKinney case at the top was a case involving age discrimination, and this statement, academic freedom and excellence is essential to our continuance as a lively democracy, was indeed what we lawyers would call obiter dicta, or a side statement that's not central to the decision. And indeed, the other 2 statements would also be obiter statements as well, that were made in the course of deciding another type of academic freedom issue. Nevertheless, I, as a lawyer, would want to be able to use these kinds of statements coming from authoritative appellate courts to be able to say, if I ever had to face an arbitrator, that this ought to be recognized as a broad right in Canada. Please, next slide. So, I'm going to briefly go through the 4 branches of academic freedom and tell you basically how arbitrators and legal decision makers in Canada have dealt with them. The first, obviously, is on the freedom of research and publication. And for each of these 4 branches, I'm using quotes coming from what I think is one of the best books written on academic freedom, which is by Matthew Finken and Richard Post from the United States for the Common Good, published probably about a decade ago. I don't agree with everything that's in there, but I do think that their listing in quite accessible language as academic lawyers is really probably our starting point for anybody who wants to dig deeper with this. Next slide, please. So, virtually all of these areas, I'm going to say to you, have troublesome protections by the courts and sometimes by arbitrators as well. The one leading case, and there's very few cases I could find, where freedom of research and publication has actually been litigated in a robust way in Canada. This is perhaps the leading case with respect to this, and it was a unfortunate decision. It comes from the Saskatchewan Court of Appeal in 2008, and this involved a initial invitation to a Dr. Stonechild to speak at a symposium with respect to his academic work organized by the First Nations University of Canada, which is an affiliate of the University of Regina. And then his role as keynote speaker was vetoed by a member of the board of governors. His union litigated this in front of a labor arbitrator. The union won. This was taken on judicial review to the Saskatchewan Court of Queen's Bench. The union won again, and that was appealed to the Saskatchewan Court of Appeal, where the university won. And taking a rather procedural and narrow point of view, the Court of Appeal said that that there was no breach of academic freedom in the invitation and then the withdrawal of the invitation of Dr. Stonechild to be able to speak with respect to this. So we still don't have in Canada any clear ringing statement in the law with respect to the breadth of freedom of research and publication. Second slide. I'm now turning to the freedom to teach. And again, here is a statement by Finken and Post with respect to this. And again, I think the language they use echoes the same kind of language we saw a few minutes ago in the 1997 UNESCO recommendation on the rights of post-secondary teachers. Next slide. So, looking at the case law, freedom to teach has been protected in a recent case coming from the Ontario Human Rights Tribunal, where there were claims of discrimination brought by university students against professors with respect to both the content of lectures and also the assignment of topics. And I don't have time to go into the details of the facts with respect to this, but they went to the Ontario Human Rights Tribunal on an allegation of discrimination, and the Human Rights Tribunal said that, quote here, the expression and communication made in the context of exploration of ideas, no matter how controversial or provocative these ideas might be, does not amount to discrimination under the Human Rights Tribunal. Now, they're looking at this through the lens of discrimination as defined by the Human Rights Code of Ontario. One would hope that this kind of case would form an important precedent if this ever went as a meaning of what the freedom to teach means with respect to academic freedom under a collective agreement. Next slide, please. But it is not protected a tenured professor who refused academic direction with respect to the marking system that had been established by the university. And in this case, this actually was the firing of a tenured professor, a highly unusual case in Canada. But the arbitrator said in the end, academic freedom concept is not so wide as to shield a professor from actions of behavior that cannot be construed as a reasonable exercise of his or her responsibilities in an academic setting. This was a controversial case at the time when it was issued, and is one of the very few cases I've come across in the unionization era where a professor, a tenured professor, has been fired over a claim with respect to his breach of academic freedom. Next slide, please. The third branch is freedom of intramural expression. And again, given the definition and the writing of Finken and Post, one would have thought that the defense of the ability of a professor to criticize her or his or their institution in the academic leadership, or to criticize each other through open debate and discussion, will be something that would be robustly protected in the law, and particularly by arbitrators. Next slide. And alas, this is one area where I've already written and published an article on. One of the very few cases, and I think this was cited in the prior presentation as well, where arbitrators actually understood and protected academic freedom with respect to a professor who criticized his institution, was an arbitration award 15 years ago, where the professor had criticized his institution with respect to elements of fundraising and corporate governance. He had been given, I believe, a a letter of rebuke with respect to his particular statements. This went to arbitration, and the arbitrator said, in one of the rare ringing endorsements, said there are a few concepts or principles more important to the functioning of a healthy and vibrant functioning of the university than academic freedom. This indeed is one of the strongest statements I've come across in reviewing a number of arbitration decisions on this. Next slide. But it's in many ways undone by the other probably half dozen decisions that I've come across on the freedom of intramural expression by professors, where their right was not protected, and certainly not robustly protected. This is one of the most disturbing of the decisions I've come across, which I've written about in another article, which comes out of the University of Saskatchewan 6 years ago, where there had been a series of cutbacks of staff at a university library. The library staff, who were unionized, then verbally criticized a manager during a meeting which management had called in order to try to explain why the staff cutbacks have been made and try to deal with the upset that some of the unionized library staff had felt. And there was actually express protection in the collective agreement, which said that there was a right to criticize the university without suffering censorship. That's the language directly from the collective agreement. And yet when letters are put on their file and when this went to arbitration, the arbitrator said something to the effect, said this, and I'll quote, "There is a subtle but important distinction," which you see there, between exercising one's right to, and freedom to criticize and, quote, "calling somebody to account." And one would have thought that calling somebody to account is precisely the sort of critical speech that a liberal understanding of intramural expression would wind up protecting. Yes, I'm almost done here. If you can just go quickly to the next slide. And this is the freedom of extramural expression, which I think is one of the most contested of areas with respect to what the scope of this is. Finken and Post actually take a rather narrow view of what extramural expression is. I think Coate and certainly the language in a number of collective agreements takes a more robust and more liberal definition. And if you can go to the next slide, this has protected a professor through a recent consent award who, when writing a letter on social matters to a local, actually it was to a provincial minister, was rebuked for it by her administration. This was actually settled positively in favor of the professor and the faculty association through a subsequent consent award. So this stands as a very initial thin reed of protection. But the next slide is an older case, which has stood now for 30 years, which took, again, a rather narrow and restrictive view of the extent and scope of extramural expression. And again, it's an area that I think the law has yet to show the kind of protection that professors are calling for. So my last slide is my conclusion. And if I can just very quickly point this out, I make 3 points here, and I'll go through them very quickly because I know we're going to go to the third slide. But the first is that the university is a workplace in labor law, but it has to be understood, and not always by all arbitrators, that it is a workplace of a special nature. Second of all, notwithstanding the fact that there's been I think, an inconsistent approach towards understanding and defining academic freedom by arbitrators, I'm still of the view that having arbitration as the key and central legal decision-making forum for litigating issues involving academic freedom is the best place to be. Why? Because I think there's more control by professors over the language in the collective agreement and over the forum. There's more flexibility, and I think there's more opportunity to wind up educating arbitrators with respect to this. And as a call for this, and what I think is really needed is, and this conference is hoping to fill some of that hole, there needs to be a lot more written by scholars about the nature of academic freedom and its importance to a vibrant democracy. And that, I think, will wind up helping us better educate arbitrators and other legal decision makers with respect to how broad academic freedom ought to be applied in this country. Thank you very much.
Thank you very much, Michael. Very interesting. Our fourth and fifth much. Our fourth and fifth speakers come from the law firm Pink Larkin, and both are located in Fredericton. And I'm going to mention that both will be speaking in French. So if you haven't chosen translation, please do so if you need it. And I'm going to introduce both of them. John McCormick focuses on labor and employment law, administrative law, and professional regulation for Pink Larkin. And Joël Michaud represents clients, including faculty associations, on all aspects of labor relations and employment. He also regularly represents professional regulatory bodies in matters of public complaints, licensing, and governance. And I'll turn it over to Jean. You start. Joël, are you starting?
Yes, I'll start.
So, Joël, thank you.
Thank you, Penny. Bonjour tout le monde. C'est très dommage que cette conférence soit virtuelle parce qu'on aurait pu être à Ottawa. Après tout, il semble-t-il que les visiteurs intéressés par toute notion de freedom, ils sont chaleureusement accueillis ces jours-ci. Mais à défaut d'être en présentiel, John et moi sommes à Fredericton, au Nouveau-Brunswick, à moins d'1 kilomètre du campus de l'Université du Nouveau-Brunswick, qui aurait, selon l'auteur et professeur Peter Kent, et non le journaliste politicien, été le site de l'invention de la liberté académique avec l'affaire Strax en 1968. Si c'est le cas, ces débuts de la liberté académique ont été éprouvants et peu prometteurs. L'affaire s'est retrouvée devant le juge Berry la même année, donc en décembre 1968. Il écrit, entre autres, dans son jugement cinglant pour M. Strax, « Apparently, the only way in which the defendant, qui était le chargé de cour, could be stopped in his childish conduct was to close the library, thus depriving all students of its use. Universities," et ça c'est un point important qu'il fait ici, par contre, universities did not always possess the rights and privileges which they now have. And a few stubborn, misguided people could easily create conditions whereby academic freedom could be adversely affected when they disregard completely the freedom of others. Donc, cette notion-là que mes droits s'éteignent lorsqu'ils ont un impact important sur les droits des autres. Le juge a octroyé des dommages et intérêts exemplaires contre M. Strax et il a même déposé une plainte au barreau contre l'avocat de M. Strax. Donc, si c'était effectivement la création, le début de la liberté académique, c'était assez dramatique. Je vais passer la parole à John qui va parler de certains développements au Québec pour reprendre la parole plus tard pour parler de deux causes, deux dossiers en fait qu'on a traités ici chez Pink Larkin dans les dernières 2 années. Donc, John.
Merci, Joël. Oui, alors tout en poursuivant les thèmes abordés par les autres conférenciers et conférencières de ce panel, on nous a demandé de mettre l'accent sur les décisions arbitrales rendues en français. Ce sont majoritairement les décisions québécoises, mais Joël vous parlera, comme il a dit, d'une cause qu'on a faite en français à Moncton, qui aurait fait la décision sur la liberté d'enseignement à l'ère MeToo si on ne l'avait pas réglée. Sorry. Il convient de souligner que dans l'espace de 2 ans, il y a eu 3 rapports importants sur la liberté universitaire dans le milieu universitaire francophone ou bilingue au pays. Penny a déjà mentionné le rapport Bastarache et le rapport Cloutier, qui sont des ressources très utiles. Et je vous recommande en particulier le rapport de Jean-François Gaudreau-Desbiens avec la collaboration de Léa Boutreuil, les libertés universitaires dans une université inclusive, qui est un travail d'une très grande érudition qui aborde le sujet d'un point de vue tout aussi philosophique que juridique. Tout cela témoigne de l'intérêt suscité par la liberté académique, surtout dans la folie d'affaires hautement médiatisées, dont celle de la professeure Verouchka Lieutenant Duval et du professeur Amira Taran. Mais ces affaires n'ont pas jusqu'ici du moins produit des décisions arbitrales et c'est à celle-là que je me limite. Diapo, s'il vous plaît. Diapo. Merci. Alors, j'aimerais m'attarder un peu sur une décision en particulier qui date de quelques années, mais qui comprend quand même l'énoncé le plus clair dans la jurisprudence d'un point très important que Michael vient de soulever, soit que la liberté académique n'a pas le statut d'un droit constitutionnel ou quasi-constitutionnel au Canada. La décision est également importante pour une autre raison, c'est que le contexte tout à fait particulier de ce grief a permis de tester les limites de la liberté académique. Je ne fais qu'une esquisse de ce contexte et j'omets entièrement les aspects de ce grief qui ne traitaient pas de la liberté académique. Mais en tout cas, voilà. Le contexte était le mouvement étudiant du printemps 2012. Il y a eu un boycott par les étudiants qui contestaient la hausse des frais scolaires et qui appuyaient la gratuité scolaire au Québec. Et ce grief ici traite de la situation à l'Université du Québec en Outaouais. Alors, face au boycott, l'UQO a décidé de lever les cours. Mais un groupe d'étudiants qui n'étaient pas d'accord avec le boycott ont obtenu une injonction de la Cour supérieure qui a forcé l'université de reprendre les cours. L'université et le syndicat des professeurs également s'est opposé à l'injonction, mais l'université ne l'a pas porté en appel. Alors, contrainte à se conformer à l'injonction, l'université a donné la directive aux professeurs de reprendre les cours. En plus, elle prolonge unilatéralement l'année universitaire et adopte un système d'évaluation succès-échec. Toutes ces décisions ont été l'objet de la contestation par le syndicat des professeurs. Également, notez que la tenue des cours a été empêchée par les manifestations et l'UQO a fini par invoquer l'assistance policière et la situation a beaucoup dégénéré et a fait l'objet d'un grand controverse. Diapo, s'il vous plaît. Alors, j'ai mentionné qu'il y a eu un argument constitutionnel de présenter lors de l'arbitrage, puis que l'argument constitutionnel n'a pas été retenu. Le but de cet argument était si l'argument avait été retenu, la liberté académique aurait eu la préséance sur les droits de direction de l'université et les devoirs des professeurs envers l'employeur, l'université ici. Vous voyez, elles auraient donc aussi préséance sur les devoirs incombant aux salariés envers leur employeur, etc. Selon l'arbitre, c'est une vision que je ne partage pas. Il n'y a aucune autorité qui a été présenté à cette séance d'arbitrage, du moins, qui appuie la constitutionnalisation du droit à la liberté académique. Alors, selon cet arbitre, cela nous laisse avec la convention collective. La liberté académique, c'est un droit conventionné comme les autres. Diapo. Diapo, merci. Le syndicat a néanmoins connu un succès partiel dans ce grief. Alors, le grief a été accueilli en ce qui concerne la directive de la part de l'université de commencer l'enseignement dès la présence d'un seul étudiant inscrit dans la salle de classe et de continuer avec la matière déjà prévue. Mais elle a été rejetée en ce qui concerne la directive de reprendre les cours. Alors, en raison de la liberté académique, l'université ne peut pas micro-gérer l'enseignement, mais elle peut exiger la prestation du travail. Également, la modification unilatérale du calendrier universitaire, qui était l'année universitaire faisait partie de la convention collective. Alors, elle ne peut pas, l'université ne pouvait pas modifier l'année universitaire sans l'accord du syndicat. Diapo, s'il vous plaît. Alors, somme toute, je mentionne quelques autres décisions très récentes. Nonobstant la liberté académique, l'université conserve le droit de gérer l'institution en surveillant l'allocation des tâches par une assemblée départementale, d'exiger le respect d'échéanciers, d'enquêter sur des allégations d'inéquité, même en ce qui concerne l'évaluation, et également de refuser de faire la promotion d'un travail de recherche d'un professeur. Alors, il y a eu peu de succès pour les contestations fondées sur la liberté académique qui ne relève pas de son noyau dur, soit le droit de diriger ses propres cours et recherches et d'être exempt de la censure. Je le passe à Joël.
Merci, John. Diapo, s'il vous plaît. Oui, celui-là. Je veux parler très brièvement de cette cause. J'ai eu la permission de l'auteur du grief, comme Mary Ellen mentionnait plus tôt, on est parfois privé d'analyses rigoureuses en liberté académique, comme dans d'autres domaines, à cause soit de la médiation ou du règlement de dossier. C'est un de ces dossiers-là, mais le professeur en question, André Zaharia, m'a donné la permission d'utiliser son nom quand même. Le dossier a été réglé, il n'est plus à l'université. Le dossier aurait été extrêmement intéressant. Il a été réglé là, sur les marches de l'Église, littéralement. Il aurait été extrêmement intéressant parce qu'il touchait justement ce noyau dur-là de cette liberté académique relativement à l'enseignement qui se heurtait essentiellement au MeToo. Alors, il faut se le dire, le droit pré-MeToo est plus ou moins pertinent aujourd'hui, comme d'ailleurs le droit relativement à la vaccination obligatoire et d'utilité limitée dans une situation de pandémie. On accusait le professeur Zaharia d'avoir sexualisé les pièces de théâtre et essentiellement, ça revenait à, il y avait 3 pièces, mais ça revenait à ce qui constitue la motivation dans les choix du professeur. Et on estimait qu'on avait certainement une bonne cause à défendre dans un contexte de MeToo. Ça aurait certainement été extrêmement intéressant et le droit qui en aurait résulté aurait pu être très utile. Finalement, la dernière cause, diapo s'il vous plaît, celle-ci a été rapportée et Penny pourra peut-être, malgré qu'elle ne devrait pas vous en parler, la décision d'Alkir qui impliquait UNB, ici à Fredericton, une cause de promotion dans laquelle le syndicat avait invoqué, entre autres, la protection liée spécifiquement à la liberté académique qui était prévue dans la convention collective. Ce n'est pas un argument qui a été retenu. Si on peut aller à la diapo suivante. Comme vous verrez, la liberté académique était prévue, protégée expressément, traitée expressément à l'article 14, mais dans ce cas-là, puis le prof, l'argument où sa promotion avait été rejetée parce qu'il ne publiait pas assez, donc côté quantitatif, mais du côté de qualité, il n'y a personne qui s'argumentait que la qualité de sa recherche rencontrait toutes les exigences. Cependant, les vice-présidents avaient quand même voté ou avaient quand même décidé contre la promotion. Donc, ce qu'on voit, c'est que l'arbitre, et si on peut aller à l'autre diapo, ça va devenir le plus clair. Bien que l'arbitre dans cette cause-là, et c'était un conseil arbitral sur lequel, comme j'avais mentionné plus tôt, Penny siégeait, bien que le conseil n'a pas donné raison au syndicat sous l'article 14, il s'est basé sur les notions qui étaient retrouvées ailleurs dans la Convention, traitant des notions de procédurales et de fond traitant de la promotion. Et le tribunal, dans une décision de 400 quelques pages, est venu à la conclusion, 420 pages, est venu à la conclusion que la promotion devait être accordée au professeur d'Alkir plutôt que de retourner la cause à l'employeur, comme on voit souvent comme remède octroyé par les arbitres. Alors, là où ça devient intéressant, cette cause-là, c'est qu'on voit que les notions de liberté académique ont été négociées à travers les années par les négociateurs de AUNBT, qui devraient en être fiers. Mais elles ont été incorporées dans d'autres parties de la convention collective, ce qui nous a permis ici de perdre peut-être l'argument spécifique sur la liberté académique, mais de gagner la bataille en utilisant les mêmes notions. Alors, c'est une leçon, je crois, que beaucoup de syndicats pourraient utiliser, mettre en pratique pour protéger ces notions-là, protéger ces protections-là, mais sans nécessairement le faire sous un en-tête de liberté académique. Juste s'assurer que les droits sont effectivement respectés. Je vous remercie beaucoup et je m'excuse d'avoir dépassé le temps alloué.
Alors, bon après-midi tout le monde. Nous allons commencer le deuxième panel de cette journée qui est, lui, consacré à la liberté académique et le devoir de loyauté. Les questions qui seront abordées sont les suivantes. Nous savons que le droit du travail stipule que les employés sont tenus d'un devoir de loyauté envers leur employeur. Alors, comment interpréter ce principe juridique sur le lieu de travail d'une université ou d'un collège où la liberté académique accorde au personnel académique le droit de participer au devoir public et au débat public, de même qu'à la gouvernance et à l'administration, et de les critiquer. Donc, nous allons avoir des panélistes que je vais vous présenter rapidement. Vous avez la biographie sur le programme. D'abord, Len Findlay, qui est professeur émérite à l'Université de la Saskatchewan, professeur agrégé supérieur pour le centre Free Expression de l'Université Ryerson et qui a été ancien président du comité de la liberté académique et de la permanence à l'ACPU. Il travaille sur la théorie et la production culturelle européenne, les relations entre autochtones et colons, la liberté académique et la décolonisation des universités américaines. Ensuite, la seconde panéliste sera Sarah Goodwin, qui est avocate générale et directrice des services juridiques et des relations de travail à l'ACPU. Madame Goodwin a travaillé pour un important syndicat de la fonction publique fédérale où elle représentait des membres ainsi que le syndicat sur des questions plus systémiques, notamment la liberté d'expression des fonctionnaires. Et je vais terminer avec David Robinson, qu'on ne présente pas, et qui est donc le directeur général, excusez-moi, de l'Association canadienne des professeurs d'université. Alors, chaque intervention devrait durer une quinzaine de minutes et on essaiera de laisser le plus de place possible pour les questions. Alors, sans plus attendre, je vais demander à Alain de commencer. Merci.
Hello, everyone. Academic freedom and the duty of loyalty, stakes and strategies in the current conjuncture. Next slide, please. I'm territorial. I have adjusted my territorial acknowledgement. I'm speaking to you from Saskatoon in Treaty 6 territory in the traditional homeland of the Métis. And I'm also talking to you from the temporary home of the worst provincial government in Canada, bar none. Now, even over Zoom, through muted microphones even, I can hear some of you objecting, no, Len, our provincial government is worse than yours by a country mile or several city blocks. But this might prove my point about variable leadership across the Canadian post-secondary sector, a sector globally admired and emulated, but a sector provincially bullied, pillaged, and stigmatized. Next slide, please. My overview for the larger paper will look at, and I'll capture only some of this here, the stakes and strategies regarding the academic duty of loyalty pre-COVID, the stakes in the current conjuncture, the strategies of libertarian mobilization, which I describe as taking liberties with freedom, the Society of the Libertarian Spectacle, currently on view in Ottawa, in Wellington, and environs. And I'll have a quick look at that through a Sartrean lens, through Guy Debord and the Society of the Spectacle, and through Michel Foucault. I'll then look at trying to conceptualize the current conjuncture and what is happening outside the gates of universities and colleges, which I'll call alienation improv and carnival as routine, capturing freedom or an attempt to capture freedom, including academic freedom, for an agglomerate of pseudo-politics of liberation. I'll then look at the duty of loyalty case for academic labor conformity with organized labor as such, and then the duty of loyalty case for academic labor exceptionalism. So two things there. The national and provincial picture, which means either pay attention to your educators and researchers or follow your favorite ignoramus influencer. And I'll end with strategies against appeasement, seeing these within the frame of the law, the anti-lumpen agency of the leaven of justice, and across the shifting terrain and mediascapes of lawlessness. Next slide, please. Academic duty of loyalty pre-COVID. The growing unionization of academic staff and post-secondary institutions in face of increasingly imperious academic managerialism led individuals who thought they had a claim to academic freedom to defend that claim wherever and however they could. While refusing to be treated as hired hands, they used two sites to affirm their status as what I'm calling employees plus. Those sites were shared collegial governance and negotiation with management of mutually binding collective agreements recognized by and subject to labor law. From the beginning of this process of organizing academic labor beyond hegemonic bourgeois gentility, beyond class collegiality, and their urformation in European church and court cultures, many ceased seeking the ear of the prince, the principal, or the president, recognizing that their academic freedom and obligation to criticize the employer had been justified once and for all in the Faulklasken report on the Harry Crowe case in 1959. Next slide, please. The report notes, and I quote, Dean Freeman of theology said that when he first read the letter written to a colleague by Professor Harry Crowe, he was of the opinion that anyone on the faculty was duty-bound to take it to the principal, and that is Principal Locker, duty-bound to take it to the principal. This ancient and persistent version of the duty of loyalty, duty-bound, infantilizes faculty while affirming a snitch culture tied to a rigid ecclesiastical hierarchy in the name of United College. This apparently justifies reading other people's mail and is certainly still relevant today as academic staff continue to assert custody and control over their correspondence in the age of surveillance capitalism, managerial prescription of duties, and responds to even the faintest murmur of off-message critique as disloyalty. But surely the structures underlying Dean Freeman's loyalist agency and its punitive results are long gone in the course of our linear progression without relapse towards a juster society, a juster institution. Not so. Next slide, please. Academic freedom, and here's a quotation, academic freedom is a central, arguably the central value of university life. Anything which interferes with it has to be justified by reference to prior and higher values. I can think of very few, other than perhaps the protection of human life. Certainly not institutional solidarity, certainly not institutional reputation. Those are the words of Harry Arthurs in a piece, Academic Freedom, When and Where, notes for an AUCC panel at its annual conference in Halifax. The emphasis on mine. What? A former law dean and university president of York from 85 to 92 is talking to his successors and sounding just like a scholar, figuring things out in public, unfiltered and free. The kids, one might infer, the kids and their teachers are all right. But not so fast. Which presidents do this now, today, in the age of Big Brander, risk aversion of several kinds, rankings fetishism, lavishly compensated CEOs, and the plutocratic academic fiduciary? Next slide, please. Before COVID hit Canada, there was a shared recognition by administrators and academic staff that academic freedom was indispensable to teaching and research. However, there was far less agreement between these two groups about its scope and relevance in the areas of intramural and extramural speech, i.e. the right to criticize the institutional leadership and their favored policies, and the right of academic staff to contribute to public debates on matters of public concern. The then AUCC's new 2011 statement on academic freedom was widely seen as retrograde, remiss in some of its assertions and in some of its silences, and an exchange of public statements between CAT and AUCC ensured and foreshadows some of the enduring problems. Next slide. The whole exchange between the AUCC and CAT merits careful and recurrent scrutiny, not least for the former's insinuation that beyond disciplinary speech on disciplinary matters, academic staff would do well to self-censor, or they would risk violating their duty of loyalty to their employer. Here is a sample insinuation from Stephen Toop and Paul Davidson in response to Wayne Peters, then president of CAUT, and Jim Turk, then executive director. Quote, "The responsibility of an institution to organize its mission is an appropriate constraint in academic freedom. For example, a university's responsibility to schedule classes and exams and prepare the academic calendar should not be encumbered by a loose definition of academic freedom." O Harry Arthurs, Bora Laskin, and Vernon Fouke, where art thou to decode and denounce such deceptively anodyne organization of the university's mission? There are contentious aspects to this, but one can almost hear, as in Fawlty Towers, an administrative sibyl insisting, "Don't mention the war, Basil." They're ignoring in their example some far more contentious issues on which they are silent or evasive. At least David Naylor of U of T could smell a rat in the new AUC statement and refused to sign on. But not so fast. The U of T's excellent statement on academic freedom is not enforceable from within a collective agreement, but from within the managerial miasma that envelops the understanding and implementation of institutional policy. Am I being unfair? Ask Dr. Azaroba or her U of T supporters for a current take on this, or dare I say, ask CAUT. Trouble at Degree Mill has continued unabated since 2011, and the now unilaterally imposed COVID protocols have added substantially to the worries of academic staff and their associations, while Alex Usher and his ilk descend from the mountain, tablets in hand, to tell their clients how to build back better. Next slide, please. The notion of a shared core of commitment to academic freedom plus contested ancillaries of peripheries was challenging enough pre-COVID, and especially after 2011. The enhanced risk now is that all versions of freedom, including academic freedom, will be ingested, transformed, and weaponized by aggrieved libertarians to subvert or invert those versions and traditions of freedom hitherto espoused, promoted, and robustly critiqued as part of the democratic way. Academic freedom's connections to excellence are already being repurposed as proof of the undeserved privilege of a pampered left-wing elite who serve those even more privileged than themselves. Time then for libertarians to uncouple science, high culture, high-minded cancel culture, and hand-wringing wokeism from freedom of any kind, and reduce academic freedom to a wedge to split the academy as thoroughly as it is dividing Canadian society, and equally simplistically. Next slide. So taking liberties with freedom, the hubris of freedom convoyeurism, in the age, I invented that word as a sour neologism to capture the selfie-taking dimensions and the visual performativity of what's happening in Ottawa and elsewhere. The meaning of freedom is a site of prodigious struggle historically and currently, and at the moment, as an illustrious term, is simultaneously emptied of meaning so as to function as a libertarian self-evident good, and caused to function as a cornucopia of ever-morphing complaints and accusations whose lack of definition and coherence protects them from the customary expectations of rational citizens and academic authorities who do their work dutifully in an anti-authoritarian, anti-Lysenkoist loyalty to discipline, evidence, and expertise. You have, of course, heard of, or maybe even seen, the Emperor's New Clothes. Now scrutinize the blustering opportunists, iconographic delirium, affirmed in flags, patches, tattoos, the insignia of the brainless harlequin packing heat, and the branch plant animus of Canadian Trumpians. And consider how this process is being legitimated by some Conservative MPs and senators, and by premiers like Scott Moe, conducting his latest composition, Concerto for Truck Horn, Dog Whistle, Oil Drum, and Super Spreader Chorus. Next slide. The Sartrean lens, we are condemned to be free, offers an existential irony and a dialectical duty tied to responsibility for human action, not a never go to jail card for free-feeling libertarians. Guy Debord's nightwear in The Society of the Spectacle was bad enough in the 1960s, and he eventually admitted it could and would get worse, while affirming that human separation is the alpha and omega of the spectacle. A place where alone social atoms can feel connected to some version of the one, white settler Christian nation, national flag, or whatever. What would Debord make of the binding of social atoms at the moment into volatile compounds being done in the name of the alpha and omicron of the spectacle? What would Harry Arthurs indeed make of this anti-institutional solidarity? What would Foucault make of the Freedom Convoy's version of parousia, fearless speech addressed to power, as speaking in tongues in the public square, or the threatened eclipse of the specific intellectual as no longer the rhapsodist of the eternal, but the strategist of life and death, by the new barbarism's generic anti-intellectual? Such questions are for me shorthand for the kind of work we have a duty of loyalty to take on at this moment, if we wish to maintain and expand connections between academic freedom and democratic values and institutions. Next slide, please. Alienation, improv, and carnival as routine. These are symptoms of desperation and vulnerability. Performative freedom seems like Mardi Gras on retrograde racist steroids, while survivor skills and supports enabling an impromptu planned occupation show a dangerous contempt for the law and for that less formal sense of leavening justice, which prides itself in attentiveness to the rights of residents and neighbors and neighborhoods and the needs of the unhoused. The longer you outstay your very welcome, the more inevitable it becomes that considerations of sustainability, occupation, rights, and freedoms will expose and counter the self-serving incoherence of your understanding of what freedom means and legitimates. I'll go to the next slide. The case for accepting the duty of loyalty as applying to academic staff, as well as to formal fiduciaries serving on the boards of governors, needs to recognize that employee status brings prescriptive letters of appointment and ongoing contractual obligations, but need not concede two claims want to be made in such context by employers. First, that the duty of loyalty of academic staff is owed to the interests of the institution as defined by its managers. Second, the assimilation of academic labor to labor in general, as exemplified by other campus unions, enables other collegial bodies to function more properly and freely because dominated by and uncritical of management, which usually calls itself leadership in such sessions. But a trade-off made to secure the advantages of certification, including clarity, enforceability, access to grievance and arbitration procedures, does not restrict academic staff's rights to determine where their fuller duty lies and how they understand and act upon their sense of duty. Next slide. The duty of loyalty, when aligned with the cautionary history of institutional autonomy and faculty purges, helps clarify why this duty needs to be emphatically refused when it threatens to function as a Trojan horse for the corporate capitalist university. Its strategically narrow acceptance and transcendence help reveal and legitimate the migration of key collegial rights and obligations from stacked senates, councils, and committees acting as management's echo chamber and star chamber, migrating to sites of collective bargaining where stewardship and enforceability are better guarantors of academic integrity, sound policy, conceived and reconceived in the public interest, and academic freedom as defined, promoted, and protected by CAUT. Next slide, please. To be sure, academic exceptionalism can be readily attacked as a mere guilt privilege. However, such attacks need to be anticipated and dealt with boldly when they occur, not by smug or defensive credentialism, but with strategic reference to the astonishing contributions the Canadian Academy makes in ordinary times, but also in extremis. In time of COVID and similarly extreme challenges, a good many of these contributions made pro bono, and all of them made in contexts of reward that throw into bold relief the obscene accumulation by compradors, parasites, profiteers, and managers. Academic staff were not getting rich, but getting sick, haunted by fears of ineffectiveness and inauthenticity during the pandemic. And yes, there should be a law against that. Next slide. We need a new academic front in formation and to contribute to it. The national picture, not books and dumpsters, remember that from the Harper years, or trucks blocking the public square. Rather, we need an unspectacular coalition of informed concern. CAUT, the Royal Society of Canada, Universities Canada, the Federal Glanton Councils, Canadian Federation of Students, Canadian Federation of Labour, populating and performing the idea of public education, K to postdoc, and into a properly compensated and enabled professoriate. These are absolutely key to any democratic advantage worthy of the name in any democracy other than the liberal ones. Your provincial picture, all campus unions in all post-secondary institutions, and your provincial and federal Federation of Labour working together for the common good. Last slide. Academic freedom, combined with the duty of loyalty in its narrow, legal, and broader justice senses, levers and leaven, offers an indispensable basis for taking on unreason in its currently virulent forms. And this must be done by academic staff members, irrespective of employment status or disciplinary seniority, all secure in an understanding of the nature of the current stakes and the lessons of the past, both recent and distant. Dare to know, certainly, but also dare to share that knowledge in ways that underline the difference between educated courage and uninformed audacity, and do so with an expectation of informed critique, but no fear of even more reprisal. Thank you very much.
Un grand merci, Len, pour ces réflexions, je dirais presque philosophiques. On va garder les questions pour la fin. Et je remercie maintenant Sarah de prendre la parole.
Thank you very much. That's a hard act to follow. I just want to say yes, Leonard. Yes. Could you put up my presentation, please? Okay. So I've been tasked with talking about the duty of loyalty and intramural academic freedom, which I call criticisms from within. Next slide, please. So I'm going to talk about what the duty of loyalty means. The duty of loyalty in a civil service setting, just for sake of comparison. And then we'll get into the tofu of the issue. I'm vegetarian. Duty of loyalty for post-secondary academic staff. And we'll look at some cases where academic freedom has been found not to apply, and in cases where academic freedom has prevailed. Next slide, please. The duty of loyalty in employment law, anyway, harkens back to the notion of the master and servant relationship. It really is that medieval. Next slide, please. It's sometimes called the duty of fatality. It's sometimes wrapped up into notions of duty, obligations of trust and candor. It's said to be owed to all employees, to their employer. It doesn't matter what the contract says. It's a very broad, non-exhaustive principle. It covers covering an employee's improper conduct that damages an employer's interests. And in fact, in Quebec, I've noticed that Quebec has codified the principle through Article 2088 of the Civil Code. So under that article, the employee is bound not only to perform his work with prudence and diligence, but also to act faithfully and honestly and not use any confidential information he obtains in the performance or in the course of his work. Next slide, please. So duty of loyalty covers or prohibits, for instance, competing with one's employer, disclosing confidential information, dishonesty, breach of conflict of interest policies. It's a big one. Public criticism of the employer. And I've left that bold because, of course, that's of particular interest here when we consider the duty of loyalty for academic staff. The duty of loyalty in employment law at large requires, for example, disclosing the wrongdoing of colleagues. And I wish I could remember the phrase that Leonard used, something about snitch culture, I believe. Yeah. There we go, there. And inventions made, the general principle is that inventions made in the course of employment are the employer's property. And of course, we know, subject to contract otherwise, that's not the case in the academic setting. So the status quo in the academic setting is that intellectual property remains with the academic. These, of course, many of these principles do apply in the academic setting. So, for instance, there was a University Alberta case in 2018. Brent was the professor's name. He was working for a university in England full-time, as well as the University of Alberta, and he hadn't disclosed that. And that was found to be a breach of his duty of loyalty. And the same, Professor Bondy with the University of Waterloo. Professor Bondy was working at a university in France while also receiving a salary from the University of Waterloo. And those two things were found to be incompatible. It was incompatible with the obligation of trust and fidelity, which is implicit in his holding of a tenured appointment at the University of Waterloo. So there are aspects of this wide principle of duty of loyalty that do apply absolutely in the academic setting. Next slide, please. So I've given you the quote from, this happens to be a University of Ottawa case, but similar quotes you find in many other cases, in fact. They talk about the high degree of independence and discretion involved in university faculty position, the heavy responsibility of faculty members and the university itself towards students, and the impossibility and undesirability of subjecting teaching and research functions to close surveillance. Haha. So that, of course, underlies the duty of loyalty in the post-secondary setting. Next slide. So just by way of contrast, I thought I would go completely in the other direction when looking at the duty of loyalty. So loyalty in the civil service, it's considered to be loyalty to the public interest as represented and interpreted by the democratically elected government and expressed in law and the Constitution. It's among the most fundamental values of the public service. Next slide. So, one of the key cases touching on duty of loyalty in the civil service was the Fraser case in 1985. That was in this before the Supreme Court of Canada. So Fraser, he was a tax office employee. He was a unit head fellow. He was extremely upset about the metric system and the entrenchment of constitutional rights and charter rights. And he became more and more public in his criticisms. The word that's used is vitriolic in tone. And the Supreme Court of Canada held that he had engaged in a sustained and highly visible attack on major government policies, and therefore breached his duty of loyalty to the government. The case didn't consider the Charter or even the Canadian Bill of Rights, but it did recognize that freedom of speech is a deep-rooted value in our democratic system of government. But in this particular case, even though the metric system and the Charter had nothing to do with this fellow's work, because he had been so vitriolic in tone, his effectiveness as a public servant was impaired, both with respect to his specific job and his wider capacity as a public servant. That's it. And they didn't require any direct evidence of that impairment. It was just accepted. So if you're at all like me, you're saying, yes, but we have the Charter. Next slide, please. So the Charter comes into being, and then we have a decision called Osborne versus Canada. It's against the Treasury Board in 1991. Another Supreme Court of Canada decision, and that challenged the constitutionality of the Public Service Employment Act, which had prohibited public servants from engaging in work for or against a candidate or a political party. And the court determined that those provisions breached Section 2B, the freedom of expression in the Charter, and they weren't saved by Section 1 because they were not minimally impairing. So that's the start of recognizing that civil servants actually do have this right of freedom of expression. Next slide, please. And it's now codified in the Public Servants Disclosure and Protection Act, which is about whistleblowing, and it sets out when whistleblowing can occur. Next slide. And in the Public Service Employment Act as well. So that's a precise piece of legislation. So an employee may engage in any political activity. This is a federal civil servant, so long as it does not impair or is not perceived to impair the employee's ability to perform their duties in a politically impartial manner. And to do that analysis, they consider the nature of the political activity, the nature of the duties of an employee or a class of employees, and the level and visibility of their positions. So a deputy minister has to be much more careful than, for instance, a scientist studying migratory bird patterns, as the famous Harper Mann songwriter was. I just want to note that despite this very clear wording in the Public Service Employment Act, there are ongoing issues going back to the pre-case of Fraser, where they keep looking at the vitriolic aspects of one's speech. So if you're vitriolic, and even though it has nothing to do with your employment, in the civil service, you may come unstuck, and that has yet to be properly fought. These things settle. Next slide, please. So now to the tofu, anyway, garbanzo bean, whatever your protein pleasure is. Duty of loyalty for post-secondary academic staff. So what we've seen is that generally, at least legislatively, there have been restrictions on employees' rights to criticize their employer, right? And this, in fact, should be even, these restrictions, the duty of loyalty, should be even less constraining on academic staff, theoretically, right? Because we have the academic freedom, which tempers the duty of loyalty requirement on employees not to criticize their employer, right? This makes sense. The duty of loyalty requires behavior consistent with the goals and objectives of the enterprise. Well, what is a major goal and objective of the university? It's to serve, as CAUT policy notes, to serve the common good of society through searching for and disseminating knowledge and understanding, and a thorough fostering of independent thinking and expression in academic staff and students. So if this is the objective, then allowing or encouraging the freedom to express one's opinion about the institution, its administration, and the system is consistent with that duty of loyalty, theoretically speaking. Next slide. So these are just a few cases where this duty of loyalty have been tested with notions of academic freedom. There's the Kane decision out of UBC in 1983. This, for any lawyers in the audience, this may be familiar because Kane made it up to the Supreme Court of Canada and set some important administrative law principles on procedural fairness. So this professor was suspended for 3 months for improper use of the university computer facilities for personal purposes. That suspension was overturned by the Supreme Court of Canada for procedural issues. He was then convicted of fraud relating to the misuse of NRC grant money, and the president recommended that he be terminated, but the hearing committee reduced that to an 18-month suspension. Next slide. He wasn't happy with that. He still issued a press release. Well, he tried to sue them in, I believe it was San Francisco, wasn't successful, but he issued a press release. And in that release, he accused the dean of making bogus representations to the Ford Foundation. He called the university, or accused the university of unethical conduct in covering up its own mistakes by accusing him, accused the university of criminal obstruction of justice, and said that one of his students, excuse me, was guilty of personality manipulation and political intrigue, including espousal of Maoist and terrorist groups. The press release, one wonders, was found to be defamatory and beyond the limits of academic freedom. So defamation isn't covered by academic freedom, and it breaches the duty of loyalty. Next slide. So in Kane, the hearing committee determined that there's no doubt that an employee owes the university a general duty to serve honestly and faithfully. And what is clear that an employee will be in breach of that duty of fidelity if they make a false public statement when the employee knows them to be false or is reckless as to the truth of the statements. Next slide. Cartoon break. Next slide. It's the Simon Fraser case. Michael Link spoke about this. So it's librarians who were reprimanded for criticizing the university's open door policy for their periodicals reading room. Sounds like it's pretty low-key criticism. Next slide. Nonetheless, the adjudicator found that one can only breach their duty of loyalty for a higher purpose. So these are the only circumstances in that particular case where the adjudicator was willing to accept a breach of the duty of loyalty. And it sounds very familiar to the cases we talked about in the civil service, right? To expose crime or serious negligence, to serve the cause of higher learning, to fairly debate important matters of general public concern related to the employer or those in authority over them. And even if you meet all that threshold, the criticism must still be fair. So a deliberate omission or negligent misstatement of significant facts will be treated as a breach of the duty of loyalty. And further, employees are expected to exhaust all reasonable opportunities to resolve the issue internally before making them public. A part of the problem in this case may be that it was librarians, and librarians, unfortunately, have had a tougher time than other academic staff in securing their academic freedom. We're working to improve that and ameliorate that situation, but that's the case. Next slide, please. There's the Mount Allison case in 1994, where the association grieved the university's failure to appoint two different professors. So one was going for the associate dean's Dean of Arts position, and another was looking for the acting director of research position. Both professors had been quite active in their union and had made vociferous criticism of the university's administration and participated in union activities, including a strike. And the employer argued that the professors owed a duty of loyalty to the university, and that they could have been, in fact, disciplined for their outspoken criticism of their president. They weren't disciplined. The only effect was that they weren't hired for these positions after the fact. Next slide, please. So the board doubted that the right to criticize the employer can reasonably be extended to cover personal attacks on the president and other senior members of the administration. The board noted that the professors were not sanctioned for their opinions. However, the president, and therefore the president, was entitled to consider attitudinal factors which militate against the establishment of effective working relationships when considering the suitability of candidates for managerial and or administrative appointments. So it's slapping at academic freedom through the back door. Next slide. This is the infamous Noble case that seems to get cited in every academic freedom article and talk. Professor Noble had prepared and distributed material on campus entitled The York University Foundation, The Tail That Wags the Dog. He alleged that specific prominent members of the Jewish community were indirectly controlling York University, leading to the clamping down of on-campus pro-Palestinian activists. Next slide. So the university issued its immediate release saying that no student should be exposed to that kind of material, which the professor had produced. But thankfully, arbitrator Goodfellow stepped in and said that the university breached Professor Noble's academic freedom. Next slide. Basically said the university could speak in some cases about a problematic faculty member, but really it shouldn't. It should leave that to the professor's colleagues to address in a public debate. There's too much risk of harming academic freedom. Next paragraph, or next slide, sorry. The last case I'll leave you with is a Bishop's University case from 2007. I think it's the last case anyway. The professor and president of a faculty association had sent an open letter to the entire Bishop's community purporting to set the record straight on comments made by a principal during a meeting with 20 managers. So the meeting itself had been fairly of limited scale, but the response was quite large. The chair of the executive committee of the corporation, so equivalent to the chair of the board of governors, responded that, like every other employee of Bishop's, the president owed a duty of loyalty to the university and its legitimate university business affairs. Next slide. And the arbitrator held that academic freedom must be exercised in a way that avoids, as far as possible, unnecessarily compromising the interests and reputation of the university, so that the professor or the president should not have broadcast their criticism to the entire university community. On the same matter, the board could not rightfully limit the professor from exercising an opinion only on matters of concern to the association. So the board had said, you are only allowed to speak president of the association of the union. You can only speak on matters of concern to the union. And thankfully, at least the arbitrator held that. On this case, I'll note my agreement with Professor Link that it is critical that the wording in the collective agreement on academic freedom does not limit it with notions of really of fairness and other limitations that we often see tempering academic freedom. Next slide. Am I done? No, I lied, sorry. One case that was touched on by our first speakers, Mackenzie and Isla. So it's Brock University, as we said, offered this solidarity experience as a broad program that was run by a Roman Catholic chaplain. A professor many people were extremely upset about this, and the chaplain alleged that the professor had harassed and discriminated against him because of his Catholic religious beliefs, contrary to the university's respectful work and learning environment policy. Next slide. And again, next slide. And the tribunal determined, thankfully, so it's ironic that this happens in a human rights context, that the courts and tribunals should be restrained in intervening in the affairs of a university in any circumstance where what is at issue is the expression of and communication made in the context of an exploration of ideas, no matter how controversial or provocative those ideas must be. And I'll let it be on that note. Thank you.
Un grand merci, Sarah. Et nous allons écouter donc notre dernier panéliste, David Robinson.
Thank you. Thank you, Françoise. I'm here.
Okay, great.
I'm just going to wait for the slide to get up, and in the interim, I will, with a cautionary note, recognize that I now stand between you and the end of another Zoom session. So I'm going to try to be as brief and concise as I can be. Still waiting for the slide to come up. What I want to look at is the issue of extramural academic freedom. We've had a number of cases come in the door recently around this. And what I want to look at is how, through a labor law lens, these cases might be approached, and for us to think about how they should be approached as well. So I want to take a look at the nature of the unique workplace of academics or out of universities and colleges, and to argue that a broader approach must be taken as well, similarly to what Sarah was arguing in terms of intramural speech, as well as to extramural freedom. So if we want to go to the first slide, or the next slide, I want to just start off by looking at what do we mean by extramural expression. And Michael Link had already highlighted this in his presentation for the quote from Finken and Post. Looking at freedom of extramural expression refers to speech made by faculty in their capacity as citizens, speech that is typically about matters of public interest and not related to their scholarly expertise. I agree with Michael that there's some problems in Finken and Post of how they then go on to further define this. But for now, I just want to emphasize that extramural expression then refers not so much to where the expression takes place. It's not about professors off campus saying something. It's about the content of what they're saying. The content is not related necessarily to their scholarly expertise. It's their exercise of their individual liberties. This is seen as a core component of academic freedom in the Canadian Association of University Teachers policy statement on academic freedom. It's also embedded, as Michael alluded to earlier, in the 1997 UNESCO recommendation. So it's seen as one of the 4 pillars of academic freedom. And in fact, looking at things historically, some of the most prominent academic freedom cases that we've seen have involved academics being dismissed or disciplined or censored not for their teaching or research, not for what they say in the classroom or for what they publish, but for their political or social views and activities. We think of Bertrand Russell, who was dismissed from Trinity and City University. Frank Underhill, professor of history at the University of Toronto in the 1930s, was under enormous pressure, not because of what he was teaching in the classroom or researching, but because of his extracurricular activities with the CCF, the precursor to the New Democratic Party. The whole imposition of loyalty oaths during the McCarthy period and the McCarthy witch hunt. And even here in Canada, Bora Laskin, whose name has come up, was subjected to a loyalty oath as a condition of employment at the University of Toronto. When he was appointed to the Faculty of Law, he had to sign a loyalty oath saying he had no connection to communism or any outside force. Lee Lorch, who eventually fled the United States and resettled in Canada, was fired not once, not twice, but 3 times. And again, he was a mathematician. It wasn't because he was coming up with weird mathematical formulas. He was an advocate of civil rights. And he actually loaned his apartment in New York to a Black war veteran that caused him to be fired by Penn State. And Penn State, in its dismissal of Lorch, said that his actions had had harmed the public relations image of the university. So this whole notion of reputation, I want to come back to later on. Let's go to the next slide. Some of the contemporary controversies that we've dealt with at CAT over the past couple of years, and some of them within the past couple of weeks. I'll just give you four examples that we can think about as we go through the presentation and think again how they might be looked at from a labor law perspective. Politicians call for a dismissal of Professor A for referring to Quebec as a low trust society in an online opinion column. Professor B tweets support for a Canadian senator who claims there were positive aspects to the residential school system. On an anonymous blog, another professor is critical of equity, diversity, and inclusion initiatives and states that Canada is not a racist society. And finally, we have a university administration being urged to act against another professor who tweets views questioning the efficacy of COVID-19 vaccines. And as you see, a lot of these incidents are happening because of, I believe, the curse of our time next to COVID-19 is the pandemic of social media. But people feel they have to express every view on social media, apparently. And this often gets people into difficulties. Next slide, please. The traditional labor law approach to this kind of off-duty conduct, again, if we think of extramural expression as not related necessarily to your core duties as a professor, this off-duty conduct in labor law, the traditional approach has been that employers don't have a right to regulate an employee's off-duty conduct unless they can establish there's sufficient connection between the behavior or expression and an impact on the workplace and the employer's interests. The leading employment law authority on this is the Millhaven Fibers from 1967 case, in which they outline one of the 5 criteria an employer must be established for justifying disciplinary action against an employee. Some of them overlap a bit. There's been some developments, but one, that whatever the conduct or expression is harms the company's reputation or product. I want to come back to reputation again because it's also mentioned later on. It renders the employee unable to perform duties. It leads to a refusal, reluctance, or inability of other employees to work with them. The offending action is also a serious breach of the criminal code and thus renders their conduct injurious to the general reputation of the company and its employees. On that one, I would just note that in a case from 2014, Toronto, the City of Toronto and the Professional Firefighters Association, an arbitrator considered that 4th factor, the serious breach of the criminal code, also applies equally to violations of workplace anti-discrimination policies and human rights legislation. And finally, the 5th point is the conduct or expression impairs the ability of the company to efficiently manage its works and efficiently direct its working forces. I want to focus on the reputational issue for this presentation here. There's other elements there that I think we need to go into as well, but I'll hopefully do that in some other form. But I just want to focus on the issue of reputational damage because it's something that's come up in a number of the cases. In fact, if we go to the next slide, you recall earlier the Professor B case that I mentioned, who had tweeted his support of a senator who was talking about what she viewed as the so-called positive aspects of the residential school system. This professor engaged in all kinds of different behaviors, both extramurally, intramurally, in the classroom. It's a very complicated case. But what I think was interesting is in the termination letter that he received, and he was terminated, he then posted the termination letter on social media. He indicated that, or the university indicated, and I highlighted the section here, that your conduct has seriously damaged the environment in your department, the overall reputation of the university, student learning, and our trust in you as a member of this academic community. And they're referring specifically to his social media postings, engagement of free speech supporters, and criticism of the university. So it's both an extramural, intramural element. If you go to the next slide, please. In the educational setting, these cases are relatively rare. That case was heading towards arbitration. It was settled outside. We don't have a lot of cases involving extramural expression of faculty members that have been litigated. We don't have a lot of decisions. But in the educational setting generally, not involving academic staff, we've seen arbitration boards and courts have found that the test for off-duty reputational harm should take into account the special position of trusts that teachers have. And one of the leading cases on this is the Ross case, Supreme Court of Canada from 1996, involving a public school teacher who was publishing virulent anti-Semitic literature on his own time. There was a complaint, he was eventually reassigned, and then there was concerns that the reassignment wasn't enough, that the person had to be gotten rid of it completely. The Supreme Court of Canada found that while the conduct was happening outside the classroom, and there was no evidence that he was actually bringing the views into the classroom or teaching it to students, Ross's off-duty expression nevertheless had a negative impact on the integrity of the school system as a whole. The court also found that teachers hold positions of trust vis-a-vis their students that impose upon them actually a higher standard of fidelity, of loyalty in their off-duty conduct. And at paragraph 44, Justice LaForest wrote, the conduct of a teacher is evaluated on the basis of his or her position rather than whether the conduct occurs within the classroom or beyond. So it actually sets a higher bar, much like public sector workers or public service workers that Sarah was describing before. Let's go to slide 7. So I think the temptation would be to apply Ross to university and college teachers, and I want to argue that there's important differences that we have to keep in mind. One, on the issue of trust and influence, I think we could argue that university and college students are not as vulnerable or impressionable as public school students, and that was certainly what the Supreme Court focused on in arguing there was a higher level of trust because of a more impressionable population that public school teachers have to deal with. I would argue, picking up on Len's points, that the more common understanding, the custom and practice of academic freedom requires that reputational harm of off-duty expression should be invoked extremely rarely, if at all. And finally, we have collective agreement language that separates us from most of the public sector or most public school teacher unions, and that gives specific contractual rights to varying degrees, as we'll see, to extramural expression of academic staff, and that has to be considered as well. Can we go to the next slide, please? So when it comes to the special obligations of academics, or whether they should be held to a higher level of off-duty conduct or standard of off-duty conduct as public school teachers, there's actually not a lot of case law on this, as I said, but some indication that we may have to do more work to persuade arbitrators in this point. This case from Concordia University cited an earlier case, which cited the AUP's 1940 Statement of Principles on Academic Freedom, partially cited, as I'll explain in a moment, in which they argue as a man, and of course this is very gendered times, of course, of learning and educational officer, a professor should remember that the public judge his profession and his institution by his utterances. Hence, he should at all times be accurate, should exercise appropriate restraint, should show respect for the opinions of others, and should make every effort to indicate that he is not an institutional spokesman. Now, this view is what John Wilson has called as the gentleman scientist model of academic freedom. It has certainly ill-served the victims of McCarthyism, who were seen to be not exercising appropriate restraint, and has left open the door for institutions to rally around the defense of institutional reputation in going after outspoken or controversial academics. What the arbitrator in Concordia didn't include was the interpretive note that the AUP subsequently added to its 1940 statement, which linked to the 1964 statement on extramural utterances, which said, and I highlighted the section there, is that extramural utterances rarely bear upon the faculty member's fitness for the position. So the argument is that extramural speech, extramural academic freedom, cannot be used to discipline employees unless it can be shown that it clearly demonstrates the faculty member's unfitness for their position. So let's go to the next slide. The second key difference in terms of academic freedom versus reputational or institutional reputation is something that Len has already referenced earlier, and that's Harry Arthur's comment that academic freedom should not be subsumed to institutional reputation, ever. If academic freedom is the central value of university life, then institutional reputation cannot trump it. Mark Gabbert also recently in an article that he published highlighted this as well, to say that the workplace, the academic workplace, is different because of the custom and practice of academic freedom, where the administration's authority over institutional governance or concern for the employer's public reputation cannot trump the right of academics to freedom of expression. Next slide, please. And finally, we have academic freedom language in our collective agreements that, to some degree or another, and to varying degrees, I would argue, provide protections explicitly for extramural academic freedom. There's actually some collective agreement language that does not include or does not reference extramural academic freedom, and I would certainly encourage academic staff associations to look carefully at that language. But we have some very broad protections. Language such as academic freedom includes the freedom of the employee to criticize the university or society at large and be free from institutional censorship. That's pretty strong protection. We have more limited protections where, as we've talked about earlier, the right to academic freedom carries with it the duty to use that freedom in a responsible way, which becomes very limited in terms of what constitutes responsibility, who decides responsibility. The next slide, please. And finally, we have some collective agreement language around discipline and dismissal that includes provisions giving the university authority to act against employees, including academic staff, in cases that undermine the reputation of the university. And I would want us to think very carefully about that and what the implications of that would be, because obviously the first stated part of it, gross misconduct, serious threats, or physical acts to the person or property of the university, but we open the door to very subjective notions of reputational harm with that last section. Or that last section, sorry. And finally, last slide, just my initial conclusions in thinking about this issue is to argue that the bar for discipline or any action by the administration against an academic staff member as a result of off-duty conduct, their extramural expression, must be set higher for academic workplaces because of academic freedom, which grants academic staff the right to intervene in public debates without retaliation from the employer. Reputational damage should rarely, if ever, I can't think of many cases where it could be used as justification for disciplining academic staff for their extramural expression. Otherwise, it drop kicks us back to the 1950s and McCarthyism, where everything becomes an embarrassment to the university. Exceptions would be restricted to cases where the law was violated, or in rare cases where the conduct revealed egregious professional incompetence. And I'd also want to recommend that collective agreement language should ensure robust and unambiguous protections for extramural academic freedom. Thank you very much.